The moving truck had barely stopped rolling when a silver Lexus blocked my driveway. The driver's door slammed, and out stepped a woman in pearls and authority. Clipboard clutched like a badge. "Excuse me," she snapped. "This subdivision is private. You can't just move in here without HOA approval." I wiped my hands on my jeans, still dusty from unloading boxes. "Ma'am," I said evenly, "this property isn't in your HOA." Her lips tightened. "Everything on this road is in the HOA. You'll need to vacate immediately." That was my introduction to Karen Holloway, president of the Ridgeway Estates Homeowners Association. Thing was, she was wrong. Dead wrong. I'd bought the land 6 months earlier, a small parcel just beyond the HOA's legal boundary line. I'd confirmed it with the county assessor, the plat maps, and even the title attorney. My property was independent, unrestricted land right next to the gated community. But the moment my foundation was poured, HOA patrol cars started slow rolling past. Notices appeared on my half-built porch. Unapproved construction, violation of architectural guidelines, even a fine for improper tree removal, except none of it applied. Their rules ended 42 feet from my eastern fence line. I kept every slip, every envelope, every timestamp. Moving day should have been the end of the stress. Instead, it was the start of the harassment. Karen came back that same evening, this time with a man she introduced as our compliance officer. He didn't introduce himself, just started photographing my front yard. "Section 8 of the CCRs," Karen barked, "prohibits visible construction materials after dark." I smiled. "Again, not under your CCRs. My deed's outside your jurisdiction." She scoffed. "We'll see about that." Then she marched to the property line, heels stabbing the gravel, and snapped one last photo of my mailbox, like she was logging evidence, for a trial that hadn't started yet. That night, I printed the county's official zoning map and pinned it to my fridge. Next morning, I found a bright orange final notice on my truck windshield. Failure to comply will result in legal action by the Ridgeway Estates HOA. I turned on my phone camera and filmed a slow pan across my fence, because what came next was going to need proof. Over the next week, Karen's campaign escalated. HOA letters appeared daily. Calls came from blocked numbers threatening community enforcement. And one morning, I caught a landscaping crew tearing down my temporary driveway markers. When I confronted them, they said, "HOA told us this area's encroaching on common land." That was the moment I knew it wasn't ignorance. It was strategy. So I stopped reacting and started documenting. I installed 3 trail cams along the property perimeter. Motion activated, time-stamped, high resolution. One caught Karen herself crossing the fence to stick another notice on my garage door. Another captured her measuring my fence with a tape while muttering something about resale value. At that point, I'd built a case stronger than any verbal argument could be. But I wanted airtight proof. So I reached out to a local surveyor, a man named Rick Salazar, retired county engineer. He agreed to do a certified boundary survey and mark every property corner with new steel pins and GPS coordinates. It cost me a few $100s, but it was about to cost Karen a lot more. When the results came in, Rick smiled. "You're 100% outside the HOA," he said. "Their boundary ends right here." He tapped the ground with his boot, "about 10 feet before your driveway starts." I framed that document in glass and set it on my porch like a trophy, but Karen didn't back off. 2 days later, I got a letter, this time from the HOA's attorney, claiming non-compliance with community covenants and demanding removal of my unauthorized dwelling. I read it twice. Then I called my own lawyer. The battle lines were officially drawn, and if Karen thought she could bully me off my own property, she was about to learn how the law actually works. The first time the sheriff's deputy knocked on my door, he looked embarrassed. "Got a complaint from Ridgeway Estates," he said, glancing at his clipboard. "Something about illegal occupancy." I handed him the survey report and my deed. He scanned them, then smirked. "You're clean. She's wasting our time." That confirmed what I suspected. Karen was escalating from harassment to false reports. So I went systematic. Every HOA letter got scanned and tagged by date. Every call from a private number got logged, with audio if it came to voicemail. Even the tire tracks across my gravel got photographed and GPS tagged. I built a digital folder labeled HOA Harassment Evidence. Subfolders: video, audio, correspondence, survey, police. If they wanted a war, I was building an arsenal of proof. Then came the trash incident. One Monday morning, I found my garbage can overturned, its contents scattered across my yard. At first, I figured raccoons. But when I checked the trail cam, I saw a flashlight beam and a figure in a floral windbreaker, Karen's signature outfit. She wasn't just trespassing now. She was defacing property. I could have called the cops immediately, but I wanted something airtight, something undeniable. So, I set up a sting. I bought a cheap GPS tracker, about the size of a matchbox, and tucked it under one of the HOA's courtesy notices she kept posting. Then I waited. That night, around 10:42 p.m., the tracker pinged an address: Karen Holloway, 18 Ridgeway Court. Gotcha. Now I had proof she was physically taking my mail and crossing property lines after dark. I forwarded the timestamps and footage to my lawyer, Tom Reeves, a property rights specialist who'd seen plenty of HOA overreach cases. His response was short: perfect. Let them keep digging. 2 weeks later, I returned home to find bright orange spray paint across my curb: violation lot. Except my property didn't even have a lot number in their system. That was it. Time for the counterpunch. Tom drafted a cease and desist under California Civil Code 1708.8, harassment and invasion of privacy. It cited GPS data, video evidence, and the certified survey. We sent it by registered mail to Karen, her board, and their attorney. Within 24 hours she was on my doorstep again, red-faced, shaking, clutching the letter. "You think this will scare us?" she hissed. "You're surrounded by Ridgeway Estates. We make the rules here." I turned my phone slightly, recording. "I don't follow your rules," I said quietly. "I follow the law." She stomped off, but not before jabbing her finger toward my porch camera. "We'll see what the county thinks." Good idea, I thought. Let's show them. That week, Tom and I met with the county zoning department. I brought the full file: survey, photos, videos, GPS logs, and police report numbers. The zoning officer, a calm woman named Dana, flipped through everything and nodded. "Yeah," she said. "We've dealt with Ridgeway before. They overreach. I'll send an official letter clarifying your property's exemption status." 3 days later, the HOA got the letter. Stamped and signed. Property at 4038 Ridgeview Road lies outside HOA jurisdiction. That's when the real panic started. The HOA board called an emergency meeting. Word spread fast through the neighborhood Facebook group. Screenshots, accusations, rumors. Someone leaked that Karen had been personally conducting compliance checks. Homeowners started to turn on her. One even sent me a message. "We didn't know she was doing this. Half of us can't stand her." Still, I wasn't celebrating yet, because Karen wasn't done. Not by a long shot. That weekend, she filed a civil complaint claiming I was devaluing adjacent HOA properties. But what she didn't realize, her own HOA's bylaws required board approval before filing legal action, something she skipped entirely. Tom smiled when he saw it. She's just violated her own charter. We filed a motion to dismiss, along with a counterclaim for harassment and trespass. And I attached a USB drive filled with footage: the trespass, the vandalism, the GPS logs. The court date was set for 6 weeks later. The story was no longer just about property lines. It was about power, ego, and how far one woman would go to enforce control she didn't actually have. And if she wanted a showdown, I was ready to give her one. The morning of the hearing, the courthouse smelled like coffee and fresh toner. I arrived early, briefcase in hand, wearing the calm confidence that comes from knowing you're right, and having proof to back it up. Karen showed up late, flanked by her board, 3 retirees with clipboards, whispering like they were about to auction a lawnmower. She wore a bright pink blazer and that same defiant smirk she'd had since day one. She didn't smirk long. The judge, a sharp-eyed woman named Judge Farley, opened the session briskly. Plaintiff Ridgway Estates HOA vs. Ryan Carter, she read, claiming unlawful occupancy and property value interference. Karen leaned forward eagerly. Your Honor, this man— Judge Farley raised a hand. You'll have your turn, Ms. Holloway. When it was mine, my lawyer Tom stood and calmly laid the foundation. Certified county map, GPS survey, zoning exemption letter, and, finally, the trail cam video showing Karen trespassing at 10:42 p.m. The courtroom was silent, except for the faint rustle of paper. Then came the kicker. The HOA bylaws, section 14.3, stating, no legal action shall be taken without board authorization recorded in the minutes. Tom flipped a page. There were no minutes. Ms. Holloway filed this action on her own. Karen's face drained of color. Judge Farley looked over her glasses. So the HOA didn't authorize this suit? No, Your Honor, one of the board members muttered. We didn't even know until last week. Then this case, the judge said, tapping her pen, is dismissed, with prejudice. A short pause. Mr. Carter, your counterclaim for harassment and trespass will proceed. Karen gasped. The next week was a parade of depositions and damage control. Tom sent the HOA a settlement offer, cover my legal fees, remove all fines, and issue a written apology, or we'd pursue damages for trespass, vandalism, and emotional distress. They tried to bluff. We didn't blink. By the following Monday, I got an email titled Settlement Acceptance. The attached PDF was the sweetest document I've ever read. Full legal acknowledgement that my property was not under HOA jurisdiction, reimbursement for attorney costs. Written apology from the Ridgway Estates Board. Karen's signature looked like someone had forced her hand. But I wasn't done. 2 weeks later, Ridgway held a special open meeting in their clubhouse. I attended, invited, surprisingly, by several fed-up homeowners who wanted the truth. When I walked in, every head turned. Karen sat stiffly at the front table, jaw set, gavel trembling. Mr. Carter, she said through clenched teeth, you're not a member of this HOA. You have no standing here. One homeowner stood up. Maybe not, but he's the only one who stood up to you. The room erupted in murmurs, so I kept it short. I didn't come to fight, I said, voice steady. I came to remind you all. Rules only work when they're backed by law, not ego. Property lines exist for a reason. Respect them, and nobody gets hurt. Ignore them, and you'll find out how expensive arrogance can be. A few people clapped. Karen slammed her gavel so hard it cracked. 3 weeks later, word spread that she'd resigned for personal reasons. Her Lexus was gone. The compliance patrol stickers on HOA vehicles quietly disappeared. I went back to my porch, coffee in hand, and watched the sun rise over my fence line, the same fence she'd measured in defiance. The gravel crunched under my boots. The cameras blinked green. Peace, at last, was measurable. In the end, it wasn't about revenge. It was about boundaries, literal and moral. You can't control what you don't own. You can't intimidate someone who documents everything. And you can't bully your way past a property pin set in stone. So if you ever find yourself staring down an overreaching HOA, do your homework, get your proof, and stand your ground. Because the law is quiet, but it speaks loudest when you let the facts do the talking. Drop your own HOA nightmare in the comments, and don't forget to subscribe for the next one. I've got plenty more stories where this came from.